number 39, Andrew Carothers versus Progressive Insurance Company. Counsel?
Good afternoon, and may it please the Court. My name is Bruce H. Letterman. I'd like to reserve 2 minutes for rebuttal.
You may, sir.
On this law day, it's particularly appropriate to open by saying that a trial and the rules of evidence are supposed to advance the search for truth, and provide for a fair trial. This case is an example of where evidentiary rulings prevented a fair trial. A bedrock principle of trial practice, which is ensconced in the pattern jury instructions, is that questions without answers are not evidence. Evidence
well, there certainly are some circumstances under which the invocation of the Fifth Amendment privilege can be mentioned, can be used to support a permissible inference. Obviously, the question here is a little different. It's about whether the invocation by a non-party can be used, right? But there have been other courts that have grappled with this issue, and many of them have said that there are circumstances in which it is permissible. Let's just assume for the moment that that is the case. Why would this not be such a case? For example, why was the testimony of the invocation of the privilege not relevant to the matter before the jury here, given the particular circumstances of this case?
Well, Judge Stein, that's exactly the issue. The question that was asked, which is the not even the penultimate, the ultimate question, Mr. Scher, are you the owner? Fifth. That does not have any probative value in this case because it is more likely than not, and I submit almost certainly likely, that the reason the Fifth Amendment was invoked was there's extensive reason to believe that Mr. Scher and Ms. Vayman may have been guilty of tax evasion, moving money offshore. There's evidence in
Isn't that related to the issue in some way because they're making a certain amount of money off of this that they're not reporting?
The plaintiff in this case is Andrew Carothers, MD-PC. Even if Mr. Scher and Ms. Vayman did something wrong, the question is, was there, in the words of Malala, a willful and material violation of law by Andrew Carothers, MD-PC? At this point, although the briefs indicate that this is not a fight over money. This is a fight over money between insurance companies and Dr. Carothers. Dr. Carothers testified he does not owe any money to Mr. Scher and Ms. Vayman. It is all Dr. Carothers' money, the corporation's money.
Certainly the jury's entitled to hear that proof, but one, to go back to Judge Stein's question, here, it seems to me the question is this relevant and is there a reason why it shouldn't come in? So I think what we were talking about was what's the relevancy? What would the inference be here, right? So other courts have looked at, among other factors, what's the alignment of interest, right? And how is that not relevant here?
The interests are exactly opposite. Dr. Carothers, who is the record owner and the plaintiff in this case, he paid a certain amount of money. There's no question, $577 or maybe $579,000 a month for renting 3 facilities. He was not working with them from his point of view. So it's bootstrapping. That's the problem here. It becomes a classic example of bootstrapping because Dr. Carothers would testify, I own the practice. The question that was asked, referred to in the opening, referred to in the summation, Mr. Scher, Ms. Vayman, are you the owner, yes or no? Plead the fifth. There is an implication that a jury would draw, not lawyers, but a layperson.
So let's assume that it was error, and the appellate term in the appellate division says that error is harmless. The evidence seems strong here. Why is it not overwhelming or fraudulent incorporation?
The answer to that is this court's decision in 1980 in the Marine Midland case. In 1980, this court set the standard that the standard for harmless error is no view of the evidence. Okay? If you read the appellate division's decision, it's quite clear that they used the wrong standard of review. The appellate division said the reason it's harmless error is, quote, the evidence clearly favored a verdict in defendant's favor. and maybe the evidence favored, but that is not no view. The standard set by this court in 1980 is no view. Evidence clearly favoring is not no view.
So
And the question,
you would argue that the standard in a civil case then is higher than it would be for constitutional error in a criminal case?
Judge Fahey, I have not thought of what the standard is in criminal cases. I can just say that the standard set by this court is no view of the evidence. And the proper analysis was the analysis by Judge Solomon in the appellate term, where he said, a reasonable view of the evidence is that Dr. Carothers had bad business judgment, was a poor manager who put too much trust in and delegated too much authority to his manager, and was a mediocre administrator, but nevertheless owned and controlled the professional corporation. You have a judge of the appellate term who reviewed the record telling you that there is a view. Perhaps the appellate division is right to say the evidence strongly favored, but that is not
But in
the
many
standard.
ways, you have to suspend kind of reality to think that this is really just poor judgment as opposed to full abrogation of any control of the entity. I mean, he doesn't even know where the money's going. He doesn't know when it's going. There's large amounts being sent to offshore accounts that's being
There
used
may-
for personal interest.
There may have been,
He doesn't know who some of the employees are.
well, Judge, I can tell you, but when you purchase a turnkey operation, as he did, he walked in, it was running well, he purchased it, I
Well,
spoke to
do
Dr.
you
Carothers.
contest those numbers, though, the disparity that Judge Rivera refers to? He took about, at the most, $200,000 out in salary, but there was $12.2 million funneled to various offshore accounts, different corporations, various leases.
But
Let me just finish the thought. Isn't that disparity striking?
No, if you understand, and this goes to another error, because if Dr. Carothers had prevailed, there's another $18 million.
Well, I understand that argument, but I'm not, that doesn't go to the fraudulent incorporation argument. That may go to another argument, but I'm having a hard time seeing how that goes to the fraudulent incorporation argument. So tell me about the acts that were actually in the record, on the record, in dispute, that disparity. How do you address that disparity for us to say, how would you have us look at it, I guess? That's what I'm asking you.
I would have you look at it as the record clearly shows that Dr. Carothers had the opportunity to acquire a business with 3 locations with rents all in of $175,000 for 2 of the locations, $195,000 for 1, and he could have made a substantial profit, and he would have made a substantial profit. And he was denied a fair opportunity. And again, I would go back to the question, and I
Yeah, but
see my...
you're back to, yes, he could purchase what you're calling this turnkey operation, but the law is clear. He's got to be the one in control.
And he was.
And the facts weigh very heavily in the other direction. I'm finding it very difficult. I appreciate the dissent below, but I'm finding it very difficult to say that that is not speculative.
Well, it's a question based on this court's standard that he had the right to have a fair trial and have a jury make that determination. And yes, could we sit and say the evidence, and this is what the appellate division said, strongly favors one view? Yes, but at the same time, Dr. Carothers, before you have forfeiture, and I see my time is up, but I request a few more minutes
complete your answer.
to address and go into the Malala issue. Dr. Carothers had a right to have a jury determine this, and he was deprived of the right to have a fair trial in this. Now, their overarching this is the question of this court's decision in Malala in 2005. Malala, what it says, and this becomes very important, the third paragraph from the end, if you read what the actual decision says is, we hold on the strength of this regulation, carriers may look beyond the face of licensing documents to identify willful and material failure. Now, willful and material, we submit, is a fraud standard. The jury charge here was essentially a piercing the corporate veil charge. It's almost identical to what you'd see in Morris versus Tax Commission of consider these factors. And what it's missing, if you have piercing the corporate veil, you have to, in just a normal context, you have to show both complete domination and also that domination was used to commit a fraud. In Malala, using the holding of Malala, which requires a willful and material violation, the charge should have asked the jury, do you find that Dr. Carothers willfully and materially or with fraudulent intent violated the law? And this becomes very important. I cited a case, 2010 case by this court, which is very significant, Glassman versus ProHealth. In that case, there was a situation where Dr. Glassman was an anesthesiologist, had a contract with an AM Surge Center to provide anesthesia services. His contract had an additional provision that said, if I work off-site, I'll split the revenues with you. The Appellate Division's second department found that that contract to share the revenues from off-site work was illegal. The exact same argument that's made here. The AM Surge Center had a license to only do surgery at a certain center. So if Dr. Glassman was working off-site, sharing revenues, the Appellate Division said that's illegal and dismissed the counterclaim. That came up to this court. This court said, and I believe it's incredibly relevant here, forfeitures by operation of law, in the context of forfeitures for alleged violations of medical regulation, are disfavored, and allowing parties to escape their contractual obligations will not be permitted. And what this court said, and I submit it's directly relevant, is that it was a malum prohibitum violation. There was not anything inherently evil, not anything malum in se about splitting revenues in a certain way. And they said, as a result, that this court reinstated the counterclaim by the AM Surge Center against Dr. Glassman in that case.
Can I stop you for a second? The way I understand the Malala ruling is Judge Rosenblatt wrote there that we're talking here about fraud in the corporate form, not in the sense of traditional common law fraud. And that's what Malala involved, and it's arguably what this case involves. And I understood your argument to be that the language that Judge Rosenblatt used there, referring to the fraud, the actions as tantamount to fraud, supported your theory that it was akin to that and that the charge was therefore error, and that was the source of the error.
Well, yes, but I'll take it further, Judge Fahey, that if you look at his decision where he says what we hold, this is what the actual holding of the case was, that requires willful and material failure to abide. So this is why there has to be something tantamount to fraud. You don't necessarily need a common law fraud charge, but you need a charge to ask the jury to determine, did Dr. Carothers act with fraudulent intent, or did he willfully and materially, in the words of Judge Rosenblatt, fail to abide by state and local law? So that if the jury, and this was the point I was making with Glassman, the way you harmonize the two decisions is there has to be more than simply an inadvertent or possible even negligent failure.
That's true. I think you're right about that. There does have to be more than a mere technical violation. And I assume that was the purpose, and it's arguably the purpose that the court set out a number of factors which in and of themselves may not have been sufficient, but in combination, in totality, may have been sufficient, and that's what we have to look at.
But what's missing from the charge to make it consistent with Glassman, to make it consistent with the actual holding of Malala, is to charge the jury, to find fraudulent incorporation, you must find that Dr. Carothers acted with some fraudulent intent, or to use the words tantamount to fraud, using the words of the decision, acted with willful. Willful means intentional. And so there has to be that. And then in considering that, you can consider these 13 factors. That's what harmonizes it with the piercing the corporate veil doctrine.
Yeah, the problem is that the language that's actually in the case where the court is talking about behavior that's tantamount to fraud, it says tantamount. It doesn't say fraud, which would be really what you're arguing. But the examples of technical violations don't suggest anything about fraud. And so one would think if they're trying to somehow draw the kind of distinction you're talking about, they might have been more express in the way they structured that particular
Well,
response.
Judge
But I know
Rivera,
your light is down, so your light is
Okay.
red.
Thank you,
I
Mr.
reserve
Lehman.
2 minutes.
Counsel?
Thank you.
Good afternoon, Your Honors. May it please the Court, Barry Levy for Progressive Insurance Company and the other insurers who are the respondents in this case.
Do you agree that, that the conduct of the incorporator here has to be willful conduct, whatever that means?
No, we don't agree at all with that, and nor does the Superintendent of Insurance, Your Honor. If you read the amicus brief that the superintendent filed in this case, what the superintendent clearly said was, we enacted the regulation to deter the very types of activities that went on in this type of case. Because dock-in-the-box schemes, which is what this exactly was, creates the problem where benefits that are available to people can be improperly siphoned off.
Doesn't even that presume some level of intentionality?
It presumes some materiality to the violation, Judge Stein. And the distinction which Judge Rivera, from the language that she read, is exactly the distinction that the trial judge and every judge to have reviewed this case has drawn in this case, and correctly so. What we're talking about here are things that go to the indicia of control or ownership. So the examples in Malala, such as failing to hold a meeting, failing to make a filing, those are ministerial acts that don't go to the heart of the control and operation test. In contrast, in a case like this, where you had evidence that from the very get-go, the doctor entered into a series of what are essentially, ridiculous leases to siphon off the profits.
Isn't it a point well taken on his side? Doesn't he have an argument that what Malala is talking about is, yes, technical violations, which may not be intentional, a little negligence there, but it's like bad judgment. You're a bad manager. And that's what Malala's saying. That's not what we're talking about. I'm not talking about bad management.
We're not talking.
And all he's arguing is can't you look at this evidence and let the jury then decide whether or not he was just a terrible, terrible manager?
Well, Your Honor, let me draw two points onto that. And first of all, in terms of Mr. Letterman's argument regarding the appellate division applying the wrong standard, I would point the court to the decision where the court says, however, given the evidence adduced at trial, the error could not have affected the outcome of the trial and was thus harmless. That's clearly the application of the no evidence standard, regardless of what the court may have otherwise said. But when you look at the magnitude of the evidence here, Your Honor, there is no conclusion that can be drawn from the trial record in this case that this was a situation where a doctor made a bad judgment. One of the things that Mr. Letterman said, which I found quite interesting, is the fact that Dr. Carothers acquired a practice. Well, he didn't acquire it from anybody. He entered into a...
Aren't there two aspects to this in a sense, in terms of whether you could say it was bad judgment? One is the financial aspect of what he paid and what he was paying. That's one. The other is the control aspect of it, which is who was controlling, who was controlling how the business was being operated, right? So
Dr. Carothers controlled nothing. He didn't control the clinical aspect of the practice. The testimony is clear about that. He didn't control the financial aspect of the practice. The testimony is clear for...
So I guess my question is, even if we agree that he was just a bad business person, or if the jury could have reasonably found that, does that end the inquiry?
But that's exactly the argument that he made to the jury. And the jury found that that wasn't accepted. The jury found on the strength of the evidence, and by the way, the majority of the evidence in this case came from Dr. Carothers' mouth, either in the form of the deposition that he gave prior to trial, or during the cross-examination that lasted almost 4 days.
So let me try and vary Judge Stein's question a little bit. Suppose that Scherer and Vayman have fraudulent intent, and they dupe Carothers. What's the result?
Same result, Your Honor. And the reason is that we're dealing here with a regulation that relates to eligibility. If a if a licensing law is violated, and regardless of whether there's intent, the healthcare provider is not entitled to payment. The superintendent of insurance, in the most recent amicus brief, which reaffirms what it said back in 2005, establishes that it has made a public policy decision. That public policy decision is that we are not going to allow this type of behavior to exist, regardless of whether there's scienter, intent, or criminal conduct. And that is for the regulator to decide in the context of the no-fault system. And Judge, it's not decided in a vacuum. Think about the magnitude of the problems that exist in the context of the operation of this practice and the lack of clinical control. One of the things that the department says in its brief, which is key, is we're concerned about patient care. In this particular case, the evidence was overwhelming that nobody cared about the patients. The only thing that the practice, and I use that term in the form, the only thing that the practice cared about was getting people in, getting the scans done, getting the bills out. The screening procedures didn't exist. The protocols for doing the scans didn't exist. Dr. Carothers didn't even know if the equipment was maintained. I mean, we're not talking about using can openers here. We're talking about pieces of equipment that have the ability to do...
How many scans did he participate in?
79.
And how many were there?
38,000. And by the way, the 79 that he claims to have read, he didn't really read them, he double read them. In other words, they had been read by another radiologist previously, and for whatever reason, he felt that he needed to read them. But going back to your point, Judge Stein, I want to address the financials.
Well, how many would he have to read? Does he have to read any?
I think he has to have a
To have
role.
control?
I think
he
to
has
have
to read them
control.
himself?
I don't think he has to read them all, Judge Rivera.
No, I didn't say that. They have to read any.
I think he has-
Otherwise controls exactly what goes on. He knows where the money goes, he sets those protocols, he hires and fires employees. Does he have to read?
I would say if he had all the protocols in place to assure that there was quality medical care, and he had the last word, okay, in the context of medical practices that exist in today's day and age, the doctors who are at the top of the food chain, they don't do everything themselves. We know that, okay? But they do things. They understand where their bank accounts are. They don't give that away to someone that they met for 90 minutes. What legitimate owner, and this is something that's very important from the trial record, what legitimate owner would sign a lease to commit himself to $12.5 to $15 million and simultaneously sign a restrictive covenant that says he can't compete with his own business?
So I take it from you, he cannot delegate these crucial aspects of how these three different places were run.
He can delegate certain things as long as he ultimately has control and responsibility for those types of things. So administrative tasks?
If we don't accept that rule, do you still win?
I still win.
Okay, what's the alternative basis for the win?
The alternative?
If we don't accept the rule you just articulated.
The alternative basis for the win is if you look at the totality of the circumstances that exist in this particular case, there is no view of this record from which this court can conclude that he was in control or that he legitimately owned the practice. Because there are, other than the fact that his name was on the paperwork, other than that fact, there was no indicia of ownership. The profits, which are supposed to go to the owner of the practice, they all went to Sharon Vyman, okay? The bank accounts, which are supposed to be in control, they all went to Sharon Vyman. Sharon Vyman is the only sole signatory on the bank account. She was the only person who could actually take a loan from the lender. She's the only person who had the ability to sign paychecks. All of the things that Dr. Carothers did are things that employees do, not things that owners do. Employees sign restrictive covenants in favor of their employers. Employees show up to their place of business every Friday to get their paycheck. Employees are the ones who get a salary and don't get profits.
Counsel, you care to address the admission of the non-party deposition?
Yeah, and I would briefly, Your Honor. As Judge Stein correctly said, a very unique set of circumstances here. And the reason one, that it's such a unique set of circumstances, because essentially what you had here is a conspiracy. You had a conspiracy essentially at its core between the lay people and the licensed professional, all right, to violate the practice of medicine. And they acted in concert with one another. So although the law, and again, this court, to my knowledge, has never spoken on this particular issue. So we are writing somewhat on a clean slate. And we don't think it's necessary to get to the ultimate conclusion here, but in the unique set of circumstances here, all of the interests were aligned.
Well, but don't they have a point when they say that it was kind of bootstrapping, that the very issue was who was in control, and the question that was asked and to which they pled the fifth, one of the many questions was that very question. So isn't that a little bit circular?
I don't think it's circular, because ultimately at the end of the day, you're dealing with people who at the time this was all going on were all one and the same. Each played their own part. They were indistinguishable from one another. No one part in this particular, within the scope of the corporation, could have completed what took place here without the participation of the other.
But assuming it was error, what's the basis for arguing that it was harmless?
Oh, very easy. When you look, Your Honor, at the mountain of evidence versus the Fifth Amendment invocation, we're talking about 2.5 hours worth of testimony in the context of a 17-day trial lasting 5 weeks, in which there were so many facts that were undisputed.
Well, it could be one question that could have a negative effect. So that isn't in and of itself dispositive. The real question is the evidence on the other side and how overwhelming it is.
There's virtually no evidence on the other side of the insurer's position here, because Dr. Carothers' acknowledgments and his admissions during the course of his deposition and during the course of the trial, he knew the leases weren't fair market value. He knew he had given up control to the bank account. He knew that, and by the way, the things about that happened, the $2.3 million that went across the ocean, all of that he knew about. He never said, oh, by the way, these people have taken advantage of me. He was all part and parcel. This is all evidence that came out of his mouth, Your Honor. This isn't a question of where we're looking at a close case. This isn't even close to a close case.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Dr. Carothers testified at the trial that he supervised the medical work here. He testified that he went around to all the facilities. He testified that he reviewed Dr. Chess's work and believed it to be outstanding.
Let me ask you this. Is there any financial evidence that you would point us to look at that would favor your point of view that this was not a fraudulent incorporation? What would you have us look at in terms of the finances?
The testimony of the expert, and the numbers are really very simple, that if you pay $577,000 a month in all-in cost to run a practice, which will make $1.3 million a month, and the numbers may sound large, but keep in mind, the state of New York sets the rates. Those are the rates. The facility is capable of doing
That's not my
large
question.
volume of
My question, I want you to stay on my question. My question is, what financial evidence do you want us to look at that favors your client's point of view that this was not a fraudulent corporation? I quoted figures to you before. It's $12.2 million taken out by Sharon Vayman. He got a salary worth about $110,000 a year. What would you have us look at that says, no, that's wrong? Financially,
wrong
that's
there, and what the judge didn't allow in is, had we prevailed.
No, I understand your 18 million argument. Setting that aside, evidence that's for the time period in question during the incorporation, tell me what I should look at.
You should look at that there was an amount that Dr. Carothers knew he was paying, which is exactly sometimes when you have a business, you have to pay your creditors before you take your own salary. And that's exactly what happened here. And it became bootstrapping to say, because you weren't paid, because the insurance companies, all 53...
If that's the case, then isn't the argument then that the creditors were in control of the business and not the doctor?
Creditors are in control of the business the same way the bank owns my house. I bought my house in 2006 before the market went down. At a point in time, my house was underwater. I had no equity in it.
But that doesn't that get us sort of back to the fact that he could have, you call this turnkey operation, and I have a little hard time understanding what the benefit of the turnkey operation is if it cost many multiples of what he could have set it up for himself, and then he wouldn't have all these creditors, and he could just pay himself and make as much, if not more, money.
Oh, that's, respectfully, that's not correct, Judge Stein.
Okay.
To set up a facility like this, and there was expert testimony, costs millions of dollars to set up a facility like this.
But there was a lot of testimony that said you could lease all of this equipment for far less than, or you could buy it and rent, or buy it and make payments on it for far less than what he paid.
But that's a very simple analysis of sometimes the whole is greater than the sum of the parts, because to operate an MRI facility, you have to have real property that will accommodate $28,000 machines, a whole setup. So when he looked at it, Dr. Carothers had the opportunity, when he didn't have substantial capital of his own, to acquire the practice, which would generate significant income. And there's nothing wrong, a lot of real estate people do it, with buying property without money. That's what he did. He had an opportunity that he could acquire something which, but for the insurance companies
Sure,
not
I get
paying.
that argument that there's a ready, on-the-ground business you can just buy and fall right in. I understand that part of the argument. The argument really is not so much that, it's that next question of, when he did that, were those really his businesses?
They
That's
were,
the bottom
and
line. Does he really control them, which is...
That's where
Your
we...
argument would be more compelling if the point is that, yes, I buy a business that's ready to go, or a medical practice that's ready to go, and then it's my medical practice. I assume all the duties and responsibilities and control of that practice. That's
that's
where we are.
what Dr. Carothers testified happened.
Mm-hmm.
That's what he had a right to have a jury determine.
What about his argument that argument was made and the jury rejected it?
Well,
What are you seeking that you
The
have not
jury-
already gotten?
the jury was, you got to understand, the insurance company started the trial by saying, you're going to hear the fifth to the question, do you own it? They ended at page 2944 of the record, asking the jury at the end of a very lengthy summation, read to the jury the question, are you the owner of Andrews Carothers MDPC fifth? This court, and I submit Judge Solomon in the appellate term was correct, we cannot substitute any of our collective judgments for what a jury would have found in a fair trial. And I would submit, when we did discuss, we're writing on a clean slate. The First Department and the Third Department have said simply the rule of law should be that the Fifth Amendment privilege cannot be invoked with an adverse inference from a non-party. I submit that should be the rule of law adopted by this court. And even if the court follows the Second Circuit's Labuti's decision, for reasons that I talk about, this case would not fall into it in my brief. But this case is an important case that the court should set the standards and remind the appellate division that the standard is no view. You still got to go back and look at what the appellate division said. They said the evidence clearly favors. But that goes back to your right to a jury trial. That's why this court's decision in Marine Midland was correct, that unless there is no view, may not be the best view, but unless there's no view, you're depriving someone of their right to a fair trial. And as I started, this is ultimately, and the whole purpose of trials and rules of evidence is to find the truth. And it was distorted in this case because of the use of the Fifth Amendment and because of the lack of any instruction regarding the element of willfulness that this court in 2005 in Judge Rosenblatt's decision said was an element of Malala to require forfeiture.
Thank you, counsel.
Thank you, Your Honors.